All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140215, Patriots Land Group LLC versus State of Arizona Department of Liquor Licenses and Control. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we've conferenced this case prior to argument. So with those preliminaries out of the way, Mr. Burry, you may proceed.
Thank you, Your Honor. May it please the Court. My name is Charles Burry. I represent the appellant, Patriots Land Group. There's just one issue in this case, and it's a relatively straightforward issue. That is, does Patriots have standing to pursue a lawsuit against the Arizona Department of Liquor Licenses and Control for wrongfully interfering with contractual relationships? The underlying facts are few and relatively straightforward. Patriots leases electronic sweepstakes equipment to charitable organizations that are licensed by the department. The department concluded that the sweepstakes being offered on that equipment were unlawful gambling.
And do they have the right to make that determination?
No, we submit that the department does not. That's a legal issue, and legal issues fall within the province of the Attorney General's office.
But isn't that an issue between the Elks and the department?
Mm-hmm. Well, not necessarily. There are different rights to be vindicated in this case. Certainly the department, I shouldn't say the department, but the Elks has the right to appeal the decision of the department to exact disciplinary action on the basis that it was arbitrary, capricious, and abuse of discretion. But likewise, Patriots has the right to try and vindicate its right to preserve its contractual relationships and to stop the economic harm, the loss of income that is occurring as a result of the department's
Well, but the loss of income
conduct.
is occurring because Elks isn't paying, so it's really once removed. And I'm somewhat persuaded by the argument in the answering brief that, you know, this would be analogous to if I'm a medical equipment supplier and I have a maintenance and sales agreement with a medical practice and the doctor loses his license. I can't then sue the Arizona Medical Board and say he didn't really incompetently treat patient A, and therefore you've interfered with my contractual relationship. And it seems to me that's exactly what your client's trying to do here.
Well, I think you have perhaps the cart before the horse. What happened here is
No, that was the last case when we were dealing with raising
Those are cows.
cows.
I came
okay?
in late. I didn't realize
That's
that.
okay. I like horses and carts better. Okay.
What happened here is the Elks stopped using the equipment because the department said, if you don't stop, we're going to take disciplinary action against you. And it predicated that order on the wrong decision that it somehow was unlawful gambling. So I think this situation is somewhat different from what you suggest, Your Honor. Again, the problem was created by the department based upon a faulty understanding of these games.
But to follow up on Danny's example, if the board that licenses doctors has some faulty understanding of the law as it pertains to licensing doctors, then under your theory, the medical supply company or the medical device company would have the right to come in and correct that misunderstanding then.
Well, let me throw out a different example, if I may, to try and make my point.
Well, I'll modify mine
Okay.
to make it more palatable to you because I think it's more analogous. So your client is a board-certified plastic surgeon who has decided that rattlesnake venom is good for treating facial wrinkles. And the medical board, and there's a supplier out there that sells him this rattlesnake venom and has a contract to do so. And the board says, absolutely not, you can't do this. So then the rattlesnake venom supplier can sue the medical board and say, that's not a violation, or it's not an unsanitary, unhealthful, bad practice.
Again, I don't think that's analogous. Let me throw out one.
Why is it not analogous? Because I, too, think it's awfully similar to what has happened here.
Well, let me say this. I don't think it's analogous because if the medical board claimed that the surgeon who used this snake oil, so to speak, was wrong because the snake oil was, shall we say, adulterated, and therefore
No, they just think it hasn't been proven medically. It's not safe. It's not an authorized medical practice.
Then could the supplier of the snake oil come back and sue the board claiming that they're wrong?
Yeah.
I think they could. I think they could. I mean, let me give you an example. Suppose the department issued...
Such a collateral attack on the regulatory action. I mean, I know we're dealing here with standing primarily. That's what the Superior Court decided. But that is clearly a collateral attack. It's a second bite in a different forum trying to say you were wrong in taking this disciplinary action.
It's not a collateral attack because the rights sought to be vindicated are vastly different. You've got the right of the Elks to be free from arbitrary, capricious, and abusive discretion disciplinary action. You've got the right of Patriots to be secure in its contractual relationships and to not suffer harm as a result of the department's wrongful interference with those contracts or agreements.
You know, the doctrine of standing, in a sense, is a litigation preemption or prevention mechanism. It excludes certain categories and individuals, or categories of people and individuals from suing. If we were to find standing in this case, it would seem to me that then any person who does business with a regulated entity or a licensed individual who didn't like what the licensing agency was doing vis-a-vis that regulated entity or that licensed individual would have the right then to bring a lawsuit to challenge what the entity was, the agency was doing. And that would then open up and I don't particularly care for the floodgates, because I'm not a fan of floodgates, but would open up the universe for third parties to sue and to challenge regulatory action when the agency was acting against this entity and it's only indirect as to the plaintiff. And I don't think the doctrine of standing can go that far.
Well, in this case, though, the disciplinary action wasn't based on really the conduct of the licensee, the Elks. It was based on the notion that the sweepstakes being offered on Patriots equipment was unlawful gambling.
Yes, it was unlawful gambling offered by a licensee who was selling liquor. So it's a liquor licensee who's engaged in, supposedly, allegedly, gambling, and that is a no-no under our statutes. You can't do that.
You can't
with
under
some
the statute,
exceptions, but yeah,
if
not,
it's unlawful gambling.
Yeah.
Let me throw out an example. I'm trying to make my point.
Okay.
Suppose the department issues an order to its licensees that you cannot sell a particular wine produced by a California vintner because, well, based on a mistaken belief that it was somehow adulterated.
Okay, yeah.
Now, in that situation, I submit that that vintner would have a cause of action against the department, irrespective of whether the licensees sell or don't sell.
But why?
Why?
What case?
Because
Why?
because the department has wrongfully disparaged its product, the
Well,
wine.
okay, now it may well be that I, as the vintner, can sue the agency for trade disparagement. There may well be claims I am directly injured by what that governmental entity do, and I have a claim because I have suffered a direct injury. But this is, what's happening here is very indirect. The Elks are suing, and they clearly have arguably been injured by the agency's action, and they do have a claim for relief, and I understand that they're pursuing it, or it is pursuing it.
But I would submit that Patriots has likewise been injured. What in essence has happened is the department has labeled Patriots equipment as unlawful gambling devices. And it said to its licensees, if you use this equipment, you're going to be disciplined. The department has disparaged the equipment that's being sold or leased by Patriots. Patriots has been damaged by that.
But that's not the claim, is disparagement. It's a breach of, you're trying to seek contract damages essentially because the party to who owes you the obligation has breached. It just seems, as Judge Norris said, very indirect. I mean, Elk's failure to pay is what's caused you injury. Now, what caused Elk's to breach,
Arguably breach.
is a very indirect. I'm just not seeing that.
Well, I think it is a direct, there is a direct relationship. Again, the reason that the Elks isn't paying is because the department said, either you stop using the equipment or we're going to discipline you. And so the Elks, faced with those alternatives, said, we're not going to use the equipment anymore. We're done with it. That resulted in injury to Patriots. And that injury to Patriots flows directly from the cease and desist order that was issued by the department to the Elks.
Now, if they issued a cease and desist, it'd be the Department of Gaming most likely, but if your client received a cease and desist order, then it's a whole different ballgame. But the cease and desist order didn't go to your client, it went to the Elks. And yes, there are certain consequences that flow from the Elks' decision to comply with the cease and desist order, but the directness of the injury is what I'm really struggling with, setting aside the whole issue of we don't have anything in the record that other licensees have been disciplined. I don't know if you want to touch on that too, but that's not probably my primary concern.
Again, the department issued an order to the Elks to stop using the equipment. The implications of that order went way beyond this one licensee. That order is in front of every other customer that is licensed by the department that uses Patriots equipment. And they're taking a look at that order and they're saying, hey, do we want to be confronted with the same situation? And they're saying no. So, again, we have this direct harm to Patriots stemming from the department's decision that the sweepstakes are unlawful gambling. We've got the Elks situation, we've got the broader situation. And the Elks business, I shouldn't say the Elks, but Patriots business has been hurt as a result. That is a particularized injury. And when we're talking about, be it declaratory relief or injunctive relief, for standing, all that needs to be demonstrated is a particularized injury.
Well, forgive me, I think the case law in Arizona requires more than just someone being injured. I think there is a linkage between the injury and in this context, the regulatory system. I'm looking at Carbell. Now,
exactly.
admittedly, that's a tax case, and I understand the distinction. But there, the person who had been allegedly injured was the taxpayer, the user of the hotel or the renter of the cars. But the court basically held there wasn't any standing because the action taken by the government affected the hotel owner and the car rental service or car rental agency. And although they passed it on, the pass-on was not enough to provide the taxpayer was standing, or the user of the room and the renter of the car.
Correct.
Right.
Correct.
I'm having a hard time. I recognize this is not a tax case, but I'm having a hard time distinguishing the approach to standing taken by that case and others like it to the situation here.
Well, if we look at the definition given by the court in Carbell to particularized injury, and we know that for standing, what's required is particularized injury. And the court in Carbell said a particularized injury is an injury in fact, economic or otherwise, caused by the complained of conduct and resulting in a distinct and palpable injury, giving the plaintiff a personal stake in the controversy's outcome. That's what the Supreme Court told us. In this case, we have a particularized injury that was suffered by Patriots. When the department...
remember in Lujan, forgive me, it went on. You quoted paragraph, basically what the court said in 12. But paragraph 13, the court made the point that causation and redressability are more difficult to prove where they are ordinarily hinge on the response of the regulated third party, which meant that there wasn't standing usually when it the injury is the taxpayer's injury depends on what the regulated party does or does not do. That then removes the standing or negates standing. And that's what the problem here in this case is, I
Well,
think.
you must understand, however, that before any disciplinary action was brought against the Elks, the department came out with a cease and desist order saying, you either stop using this equipment or we're going to bring disciplinary action against you because this equipment permits unlawful gambling.
Or your use of it. If they didn't sell liquor, wouldn't be a problem, would there?
Well, with the department, no.
No, right. So it is the combination of the licensees selling liquor where there is, according to the department, unauthorized or illegal gambling.
Well, Your Honor, let me pose this. Suppose the department came out and said, as it did, it said, we believe these sweepstakes to be unlawful gambling. Elks, you stop using the equipment or we're going to bring disciplinary action against you. The Elks stops using the equipment. The department never brings disciplinary action against the Elks. Does Patriots have standing to challenge that labeling of its equipment? I would submit yes. Because, again, it's disparaging the equipment that Patriots is offering to lease to licensees.
So here's a real-life example. There's a very well-written opinion a couple of years ago saying that Arizona can ban fish pedicures because they are not hygienic. The Board of Cosmetology shut down Cindy Vong for doing that. So then the people who supply fish to her and fish tanks and fish filtration equipment, I'm looking at my law clerk over there who helped me draft that opinion. It was very well done if you haven't read it. But so they can sue the Department of Cosmetology because Cindy Vong cannot perform fish pedicures any longer. That's got to be yes, right?
The suppliers of the equipment,
Yes,
because it's non-hygienic?
right. It doesn't comply with cosmetology requirements in Arizona.
And this is besides any disciplinary action? It's just,
Well, they also took, she quit doing it because they took disciplinary action against her.
okay, well, let's say without the disciplinary action, yeah, I would say that the supplier would have standing to bring suit against the department for labeling the system or whatever it was as being non-hygienic.
Seems like it opens, floodgates, can of worms, whatever you want to say. I just don't know where the liability for declaratory and injunctive relief ends with a regulatory agency then.
Perhaps the situation would be different had the department said, okay, we're going to charge the Elks with unlawful gambling activity. And then during the course of the proceedings, brought forth evidence that it believed demonstrated that the sweepstakes were unlawful gambling. But it didn't follow that route in this case. It came out initially with this broad-based cease and desist saying, this equipment offers unlawful gambling. You've got to stop.
But the Elks have the right to contest that, correct?
Well, the Elks do now, having been subject to discipline, but it's only one of several arguments in that case. The Elks can challenge the disciplinary action on the basis that the sweepstakes was not gambling. It could challenge the disciplinary action on the basis that it could avail itself of the non-charitable organization exemption that's set forth in the gambling laws 133302. And it could challenge the disciplinary action on the basis that it was not knowingly permitting unlawful gambling, which is the language used in the statute. So the issues would be different in this case and in that case. They're not the same.
They've still got an appeal going, so is your other client's claim even ripe at this point? Because the Elks may win.
The Elks may win, but that doesn't prohibit the Patriots case from going forward. I mean, think about it this way. Suppose we've...
Initiates the whole basis of the lawsuit.
Well, think, if you would, Your Honor, think about it this way. A and B are in an auto accident, supposedly due to the fault of C. A brings a lawsuit against C for damages, and the finder of fact determines that C is not at fault. That decision does not negate the standing of B to bring a lawsuit against C. That case can still go forward. There's no collateral estoppel. It's not a collateral attack. And the decision in A's case doesn't negate the standing of B. Again, the interests to be vindicated, the rights to be vindicated in the two cases are different. I've got about a minute left. If I could reserve that, I would like to do that.
Thank you.
Thank you.
You're not Sarah Seltzer, that's for sure.
No. And may it please the court, my name is Michael Rain,
Thank you.
Assistant Attorney General, appearing on behalf of the Department of Liquor Licenses and Control. And I did participate in the drafting of the briefs, and Ms. Seltzer's no longer with our office. The Patriots lack standing to challenge the department's decision regulating one of its licensees for violation of a department statute. And the department has essentially two arguments that it's raised in its brief. One is that that case, the Patriots lawsuit, is a collateral attack on that judgment. The second argument is essentially the general standing arguments that have been raised. Before I jump into those two issues, I kind of want to skip ahead to the end and talk about the remedy that Patriots is seeking. And Patriots has brought this case under the Declaratory Judgment Act. And that act, pursuant to 1842 and the many cases interpreting it, the purpose of that act is to afford relief from uncertainty in legal relations. And I submit to you that the best way to actually give Patriots the relief that it's seeking through the Declaratory Judgment Act is to affirm the Superior Court's decision. Because as this court has, it seems, acknowledged in some of the questions for the opposing counsel, the situation will become untenable. You're not going to get any certainty by having two inconsistent decisions out there. One, in the Elks case, that's going to go through the full administrative appeals process that's currently on your docket now and will be decided on the merits. If nothing happened, if no lawsuit was filed by Patriots, it won't get any more certain than that. You're going to have a final decision on the merits arising out of the case that had come through the path of the administrative process with the fact-finding, evidentiary hearings, review at the administrative level, and which, with the passing of time, since the filing of the complaint and even since the briefing, has now been affirmed on appeal at the Superior Court.
And I'm sure you don't think the Elks will win on appeal in this court, but if they were to prevail on appeal, doesn't that vitiate the whole stated basis for the lawsuit by Patriots?
It would, in a sense, eliminate the need for it, because I think they would have what they want. Obviously what they want is a decision that is different than the one that was already issued by a different court without the benefit of all the fact-finding and perhaps without the benefit of some of the deference that's given to agencies in the administrative context. But no matter what happens in the Elks case, it'll be a decision that stands alone. Assuming this court decides this issue in our favor, it will be a decision that stands alone resolving that issue on the merits. And that will not only give Patriots the certainty that it seeks in its action, it'll give the Elks the certainty it needs, it gives the department the certainty it needs, and it gives the entire licensed body the certainty it needs. The best case scenario for Patriots is that, I guess in their estimation, is that they win and they get a separate decision that says, this court feels that the department erred in its decision. And I just don't see how that gives any certainty. The Elks will still be subject to their case. And if that case isn't decided in their favor, the Elks is in no better position, and there's no certainty that the Elks will continue operation. In that case, the Elks won't be a party. They won't be subject to any order. The department will still have in its pocket a decision perhaps on the merits in its favor. And so I think the point I want to make in this opening is that sometimes, courts, they want to look for an avenue for a party to seek redress. And the Declaratory Judgment Act is liberally construed. But at the end of the day, you really don't need to split the baby, in a sense, in this case, because actually by denying relief, I think the practical effect will be to improve the Patriots' position if their action is truly a declaratory judgment action. And I submit that that's not what it truly is. Even though it cites that as the basis of the case, it's hard to look at it as anything other than an appeal of the agency's decision, a collateral attack. The complaint specifically says that it's the decision in the Elks case that's wrong. It doesn't say that was a purely legal issue. Indeed, in the appellate briefing, and what Mr. Burry has just argued is that we have a different situation, a different factual pattern here. And I would argue that even if that is the case, then you have an advisory opinion, because now you're asked to decide a mixed question of fact and law in a different case that has never been adjudicated anywhere, and there's no certainty that the department will do anything. So with regard to the end of this case, I would say you should feel comfortable citing in favor of the department, because that would actually be the best end result, I believe, for Patriots. This is a collateral attack. Essentially, that's a separate case challenging the effect of a judgment in the prior case. That's exactly what we see here, especially when you see the injunctive relief component that says you can't enforce your decision. So to say that's their case, that's that party, this is a different case and different rights, then how is it that those rights are going to then be given back to the Elks, and the department would be unable to enforce their decision against the Elks or any of its licensees? That's the exact effect that this complaint was designed to achieve. In Rower, in the Rower case that's been cited in the briefs, this court said quite clearly that there is no avenue for a non-party to an administrative proceeding to proceed under the Judicial Review Act. And this isn't purportedly a case under the Judicial Review Act. But that said, you look at the harms that this court was acknowledging would exist, and I think it's the same harms that we see in this case, and that is that, as this court has noted with its very good examples, anybody who won't have standing, the purpose of having a license is to go out and do business, presumably, and you go out and do business with other parties. And so if any person who can articulate some damage can then challenge the department's decision, the department would be subject to a never-ending series of potential decisions. The other harm that...
Mr. Raines, let me ask you a question. And I know, I'm asking a question, and I know my question does not necessarily suggest the facts in this case, but is there a situation in which a person could have standing to challenge actions taken by the government that directly operate on another person that would affect the plaintiff's rights? What comes to mind, I'll give you an example, is the standing of a woman to challenge an abortion regulation or abortion prohibition that may well direct doctors not to perform certain types of abortions. But we have a lot of case law, I believe, that the patient can independently sue. Now there, in that context, the patient has a constitutional right, which has been well recognized by the courts, to obtain an abortion. And you can put this in different contexts. That's just one that immediately came to mind. But there's a right that the individual has under the Constitution that's being directly affected. Is there anything analogous in the regulatory context here? Because, see, Mr. Burry makes the point, well, my equipment's been defamed or disparaged, assuming that you can disparage equipment. I don't know if that's a right, but is there something analogous that you're aware of?
I'm not, and I've racked my brain,
Okay.
because this court, in its opinion in Rower, had about a paragraph saying, we're not saying that the party that lacked standing in that case, we're not saying they don't have somewhere they can go, that there isn't some sort of claim in the Superior Court. And they cited an Arizona horticultural case where I think the court in that case essentially suggested that they might have access at the administrative level. And I wouldn't concede that, representing agencies, because we don't want a bunch of non-parties coming in and intervening. And at the end of the day, when I couldn't come up with the answer, I soothed myself by saying it's not my job to draft their complaint, and it's not this court's job to draft their complaint properly. But I do think that many times in our standing cases, someone's been harmed, and there's no doubt about that. But as you've noted, Judge Norris, standing requires more than just the harm. And the example you give reminds me of the it's the Planned Parenthood case that's cited in the briefs, where in that case, the women who had gone out of state and had out-of-state abortions were then deemed to have lacked standing. So I think perhaps the way I see it would be that you'd really need to have some certainty, perhaps, and maybe in that context it's just such a hotly contested, controversial issue that it's really hard to speak about without
And
getting
I didn't mean
political.
to raise one that's so loaded
No,
with
yeah.
controversy. I just couldn't think of one
But I completely understand what you're asking, and I guess the only way I can answer it honestly is I don't know how that would be. It would take some artful pleading. But I suspect that no matter what you tried, if the facts were as they are in this case, it would either be unripe, because no government agency in this context has indicated in any way that it's going after the Patriots. At least that's certainly not alleged in their complaint. You know, they did raise in their reply the idea that the Department of Liquor does have police, fully commissioned police officers on their staff, but that's not actually in the complaint allegation. That's not the damage that they're worried about. But I just don't see how you would have standing, or that something would be right with an actual case in controversy, until the government had taken direct action against that person. And again, I don't want to draft their complaint for them in the future, but I would suspect that the defendant in that case would probably be the Department of Gaming. That's my suspicion. But that's not what we have here today. And I think that the collateral attack issue, it's rather straightforward, and it's mostly, my position on it is it's mostly the effect of the lawsuit. It might not be directly called a collateral attack, but or an appeal under the Judicial Review Act, but I don't think there's any way to get around the fact that that would be the effect of it. So unless there's questions about the collateral attack, I would just move on to some of the other issues in general about standing. And Judge Norris, you talked about the issue of causation, and I would agree. You mentioned the Carball case, and then there's also the Bennett case that's cited on the briefs. And in Bennett, you had a woman who had essentially created a festival and had run it for many years, and was the applicant for the permit for the Yavapai County Courthouse Square. And then the county came up with this new ordinance that said only a nonprofit can apply. Well, so she applied through a nonprofit, and that nonprofit didn't get the permit. And when she appealed, I don't think anyone would say that this person who created the event in the first place and had been running it for years, maybe decades, wasn't sad about the ruling, as my law school professor would say. Someone's sad about this ruling. She had some harm.
Say that about mine all the time.
That's true. She had some harm. But what the court said was, but you're not the applicant. You know, so perhaps for her, just as in this case, there was some other way to get herself in court, and perhaps next year she did. I don't know the actual way it played out, but if she then went and applied as an individual, not a nonprofit, then she would have had standing, because she would have been denied a permit on that basis. And it's a very similar case here, where the government, the department, has not regulated this entity, and so it does not have standing, because the causation, there's a break in the causal chain, essentially, whereby another party enters in and affects the outcome, and that this court actually doesn't have before it in this case, so it can't really control their conduct. And as I've said again and again, if we have two inconsistent decisions, I don't think it's safe to assume that licensees are going to go ahead and say, well, we'll take the Patriots' favorable decision and ignore the one that the department has currently standing. Also, with regard to advisory opinions, this court has repeatedly said that it won't issue advisory opinions. And I submit that essentially what the Patriots are looking for is a blessing from this court that its business practice is lawful. And this court would never do that. And so the only way to somewhat push it closer to the type of opinion that this court would issue that wouldn't be an advisory opinion is to say, we actually have a case. This is actually occurring. But then that brings us back to the collateral attack issue. So I don't see how there's any way to have standing in any sense when there's no department regulation, we don't have any facts, we don't have these other licensees in front of us and know what they're going to do, without pointing to the existing case that was decided by the department on developed facts from hearings. And it occurs to me as I'm sitting right here that with the passage of time, things have changed too. They're no longer challenging just the department. The Superior Court, as an appellate court, has now affirmed it. So essentially, they're saying that the appellate court's wrong too. And the one thing I've never understood about the complaint is the wrongful interfering tone, at least. I mean, it says that generally. It's not super clear that that's the basis of it, but opposing counsel has just said that a few times here in oral argument. I don't understand how it can be wrongful interference for the department to regulate one of its licensees. The only way it's wrongful is if the decision was wrong. And that, again, it brings us back to the collateral attack issue. And also another point I'd like to make is that there was an expression essentially of the idea that that case was not based on conduct. The Elks case that's before you on your docket was not based on conduct, but I think if you go look at the administrative law judge's decision that was attached to one of the briefs, you'll see that it was clearly a mixed question of fact and law. You had issues of knowingly, that's always typically going to be a fact-based decision. There is an argument in the Patriots briefing that actually things have changed now. They used to only give a certain amount of free entries, and now people have unlimited free entries. And that's asserted for you to look at this as a different kind of case. But I think that at the same time tells you that it was based on the facts of that case. Also, there's the issue of it could be a raffle. And the raffle issue brings in elements of control. If you look at that exception for the raffle, you can't have a non-party, a third party with the right to control the endeavor. So I would assert that the Elks case was very much based on facts in addition to the law, and so that the idea that you can bring a different case on unknown facts and uncertain issues, it's going to be an advisory opinion. And if it's not, then we need to respect the fact finding and the case that's actually occurred. Those future cases, if they do occur, should also have their fact finding occur in the administrative field. There's numerous cases that say it's the department's purview to initially resolve those facts, and then they're given a certain amount of deference in their fact finding. I don't have much else to offer. I would be happy to answer any additional questions.
Thank you. And brief rebuttal, Mr. Burry?
If I may, this case does not seek an advisory opinion. There is a justiciable controversy between the department and Patriots. The department is claiming that the sweepstakes offered on Patriots equipment is unlawful gambling. Patriots says it is not unlawful gambling. And Patriots is entitled to its day in court to demonstrate the wrongfulness of that decision by the department. Now, in terms of standing, I think we have to recognize that Patriots, under the law, has the obligation to pursue its own interests, its own claims. It can't rest its claim for relief on the right of the Elks to appeal the disciplinary conduct, or I should say disciplinary action taken by the department. I mean, if it did that, it would be folly. What would happen if the Elks didn't appeal? Or what would happen if the Elks appealed and then abandoned its appeal? Or what would happen if the Elks didn't pursue the argument that the sweepstakes were not unlawful gambling? Were that to happen, Patriots would be without a remedy. So I would submit that indeed Patriots does have standing to vindicate its rights in this case, to demonstrate that the sweepstakes are not unlawful gambling, to protect its contractual relationships with the Elks and others, and to prevent the economic harm that it's suffering as a result of this mislabeling of its equipment by the department. Now, the department suggests that, gosh, there might be some problem if there are inconsistent decisions. If one case should find that it was unlawful gambling and another case should find that it was not unlawful gambling. But that happens all the time. Similar issues are submitted to the court. Superior Court may come up with conflicting opinions. Those opinions become before this court, and this court or the Supreme Court reconciles the two. I mean, I think back to, was it last year or the year before? I think this court came out with conflicting decisions on the notice requirements under Rule 55. It happens. It happens. But just because the same issue is being addressed by different courts doesn't mean one or the other is without standing to pursue that claim. Patriots has standing.
One last point?
One last point is this, and counsel was right. The sweepstakes in this case and in the Elks case are different. The sweepstakes being addressed by the court in the Elks case is an older version that was being offered by Patriots back in June of 2012. The sweepstakes in this case is a later version that was later offered. So there are factual differences as well. Thank you very much.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.